everybody. This is the panel called Explicit Data Flows. I am Gloria González Fuster from the VUB in Brussels, and it's really a pleasure to be here with you in this panel. This panel is not completely clear from the program, but it's part of a series which is directly sponsored by CPDP, which means by you. So thank you for sponsoring this. And it's a part of a series which is called, we codenamed the Gender Feminist Panels. We have had this series of gender feminist panels for 5 years already, and we started very small. We were put in a little room, then we were moved to another room, and this year we are here in the main stage already. Last year we were in the main stage, but at 8 o'clock in the morning. This year we are in the main stage at a reasonable time, and I was very happy with this. When I saw this, I was very happy, but happiness is always limited. So a few weeks later, I was told that actually I had to move to another stage, which I said, no, I am not moving to another stage. And they said, no, you have to move to another stage because the Friday afternoon we will be discussing in the main stage at tech, and you have to move. And I said, no, I'm not moving. And the good thing now is that we didn't move, and actually we will probably, perhaps, discuss still a bit of ad tech. So if you really want to discuss ad tech, please stay. And otherwise, we would also discuss this issue of the explicit data flows. So what is a gender feminist panel for us? We don't really know. We have been thinking about this for a long time. My perception now is that the gender feminist panel is the panel that talks about what others don't talk about. Why don't they? Because they don't want to. They think these things don't matter because they don't dare to talk about whatever. We don't know. We just think there are some subjects that we need to discuss. And this is why we have this series of panels. This year we are discussing the processing of data about sex life and sexual orientation. Why is this so important? Of course, because of the GDPR. You know or you don't know that one of the novelties of the GDPR is that it does mention explicitly sexual orientation. So one of the special categories of data, sensitive data, is data about sexual orientation. Previously, the Data Protection Directive protected data about sex life. It's not necessarily the same as sexual orientation. In any case, there is now an explicit mention that data about sexual orientation is protected. Why? Why do we protect data about sexual orientation? Basically, for one basic reason, is that everybody is free in this planet, everybody is free. And the second point is that not everybody agrees with this statement. And we know, you know about the Eurobarometer survey, we know that 1 in 4 persons in Europe don't agree that all human beings have the same rights, and they think that some human beings don't have the same rights. So there is a state of mind that in some places, a discriminatory state of mind, as the European Court of Human Rights has recently stated. So therefore, we protect this data about sexual orientation in Europe, and we try to. And the question for this panel is also what happens then with this data also flow to other places where perhaps there's no adequate protection of data, and perhaps there are also even worse states of mind regarding discrimination. So I think we have an important subject, and we have a great 4 great speakers. They are not all corresponding to the speakers that were in the program. We will come to this later. There was a little change. It has an explanation, but we'll come to this. I will start by just finishing my introduction, giving the floor to Elizabeth Coombs, who is, has a long title because there is a United Nations Special Rapporteur on Privacy, and she's the chair of the Taskforce about Privacy and Personality. She has been doing some great work about gender and privacy. She will explain more. She's also, she had been previously a privacy commissioner, which is good to know, of the Australian state of New South Wales, which has no relation with the South Wales of which we have been talking about facial recognition. This is a good joke that I was thinking, but okay, please have the floor.
Thank you, Gloria, and also to the CPDP for championing this panel, and to actually have the opportunity to be reunited with some panel members. But also, too, I'm very conscious that this is sort of the last afternoon of 3 days, and I really appreciate that you're taking an interest in this topic. Look, by way of some background, as Gloria said, I chair on behalf of the United Nations Special Rapporteur on the Right to Privacy, a task force which, amongst other things, is looking at a privacy perspective a gender perspective on privacy. And that work has been a very unfolding and evolving piece of work, which is actually revealing very many issues, which I'm going to run through. But in conjunction with that, if time allows, I just wanted to go through some work which was undertaken independently with a former colleague of mine, because it's actually very relevant to the whole data protection regulation of this privacy and gender issue. I'd just like to also point out that the views that I express are those of my mine, and not necessarily those of the Special Rapporteur, and that's just a point I would really like to make clear at the very beginning. And last but not least, I'm very severely jet lagged, and whilst I have coffee here with me and I have my notes, I do ask for a little bit of forbearance if the brain and the tongue don't always necessarily connect. So let's move on. Whilst we generally think of privacy as something which is the same and for all, but we do recognise that people have different views of what privacy is and what it means to them, we don't generally think of it in terms of the differences which gender make for privacy. And that's one of the key things which has come out through this work. The work commenced formally, although it had been going on since the time that the SRP started. In 2018, we did an online call for submissions, and that we got a very great wealth of information, largely from CSOs, academics, individuals, and also to one data protection authority. So, one of the things I would just like to start to say as by way of background is that when I use the word gender, I'm not just using that in terms of women. I'm meaning it in terms of binary gender, male, female, sexuality, sexual orientation, gender identity expression, and sex characteristics. And this is really a very important thing to understand when I go through some of the points which occur and which we have found that people experience privacy differently. But one of the factors here is that it is gender which is so profound as to how we experience our privacy. And also too that privacy is not limited to individuals, but also the effects of privacy infringements can affect whole communities. Just some additional background, I would just like to make quick reference to some of the decisions and general comments of the Human Rights Committee. In 1994, in Toonen versus Australia, it found that consensual adult sex between people of the same sex was a privacy matter, and in 2017, they reiterated that gender identity is also a privacy issue. And many people don't actually make that connection. One of the other issues I'd just like to emphasise is that we see physical autonomy as a very important component of privacy as well, which comes out particularly in the work in the intersex children's area. Now, one last point from this slide is that the effect of gender and how that's experienced in relation to the human right to privacy is affected by other factors. Intersectional issues arise very much in this area, and that can be for a variety of things as listed there: socioeconomic status, racial and ethnic origins and age, amongst other factors such as disability. Now, just to move on to what the submissions and research revealed, as you can see there, we actually acknowledge as well that not only is this about infringements, but also about the benefits. And the benefits of technology and privacy are also experienced differently, as are the downsides. And one of the things which is particularly important is how those differences are affected by structural inequities, and that link with discrimination means that sometimes privacy infringements fall particularly heavily on women, non-binary genders, the poor, and minority communities such as religious or cultural minorities. Now, one of the sort of key points is that we frequently think of privacy and gender as sort of image-based abuse or revenge porn, it's more commonly known. But there are other ways that this is being manifested which are not necessarily so obvious. A particular point was brought out about smart home technologies and how in domestic violence, which is principally directed at women, that these technologies are being used to surveil women, to find by their partners, to find out what they're doing, to control their lives and that of children and other dependents, such as the cameras ensuring that the lights and the temperature can be altered remotely by someone else. And some of the other sort of issues which come out around these areas is how surveillance and doxing is particularly directed at gender diverse individuals, also at women human rights defenders. How internet filters can particularly make it far more difficult for questioning youth who are looking for gender information to actually prevent access to that information which they're needing to explore their sexuality and gender orientation. How difficulties associated with actually obtaining legal documents that establish legal identity are a particular issue for transgender people, and how non-consensus medical interventions, particularly important area for intersex children. There are so many issues which were raised that I've got, it was a 25,000 word report, so there's no way that in 10 minutes I'm going to go through it all. But you will find it as Annex 2 to the Special Rapporteur's report to the Human Rights Committee of March of 2019, if you're interested in that. One of the big areas that came out was concerned social media and the behaviours of the big tech companies. This was an issue that was particularly stressed, largely because of the virulent cyber abuse which is directed at people who are gender diverse and at women, amongst others. And the behaviours of the big tech platforms were particularly criticised and seen to be lacking in responsible action when complaints were brought to them, and that the lack of action by the big tech companies to gender-based infringements of privacy, which led, for example, to violence, was one of abandonment, and that's how victims experienced it. They were abandoned. And in some countries where it's perceived that the state, as well as non-state actors, are actively encouraging and have a very sort of rigid view about gender identity and the like, are using these means to also track, surveil, monitor, and worse, people who do not conform to gender or binary norms. Now, let me just move this on. So combined with the lack of state enforcement and strong regulatory action by state actors, there was a perception that some of these gender-based infringements of privacy were actually, if not tolerated, certainly encouraged in certain parts of the world. See, these submissions came from all around the world. They weren't just from Europe, for example, or the Western industrialized countries. There were ones where we were talking about very traditional societies where women were not allowed to have the means to express themselves, to allowed to have privacy from those who wish to monitor their behaviors. Now, why do I think this is important, and why do I encourage people to actually take this issue seriously? Whilst this has been memorably put to me as, toughen up, princess, this is the way that the world is, and it's been like this for centuries, and we should just all get over it. These harms are not just limited to individuals, and they're not just expressed in terms of the physical and psychological harms which are listed there, but the facilitative effect of privacy, which enables us all to enjoy other human rights, such as freedom of expression, the freedom of assembly, are affected. And in particular, it also concerns me about the way that this is impacting upon our democracy and our society. For example, when young girls and women see the way that cyber violence is directed at women who have a high public profile, they are opting out of sort of seeking to have influence in the public sphere and not to seek civic office. There's a body of research on this, and I'll only touch upon upon it today. But privacy is not just an issue for the individual. It's a very important part of the fabric of a robust and sustainable democracy. No. The last point I would like to make here is that, and as I say there, breaches of privacy based upon gender, sex characteristics, gender identity and expression are a systemic form of denying human rights. They reflect, in my view, and perpetuate historical and unequal social, economic, cultural and political structures. And this is why it's of an enormous concern. One of the things which has come out is how much privacy acts to actually protect people from discrimination. Because once your details of gender are known, you can become a target, not just for cyber abuse, but also for physical abuse in the real world. To get to the last point of today's session about effective protection, around the world, there are very different approaches to privacy protection, and I think it's important to just say one of the strong messages which came out from the submissions was the need or the call for international leadership and to actually call out actions about privacy infringements based upon gender, but also for guidance as to what one should do. Yes, human rights impact assessments are incredibly important and useful to actually assess when certain innovations or changes to practice procedures or technologies might have a gender impact. But people don't necessarily know what to do about that. And this is one of the things which was actually raised strongly in the submissions. Now, I come from a country, you'll know from my accent that I'm from Australia. We do not in Australia have a constitutional right to privacy. We don't have a Bill of Rights that enshrines privacy. Our national legislation has exemptions for businesses which have under 3 million turnover per year, so small and medium enterprises. It also exempts employment records. And when I last looked at it, a quarter of the subnational jurisdictions do not have any legislation that governs how their public sector manages personal information. So I, as a citizen of a country like that, and has also been a privacy commissioner and had a long career in the public service, see how incredibly important international leadership and statements about what is appropriate can play such a critical role, along with a well-resourced CSO sector and the research which actually backs it up. I think there's just a few more points I'd like to make, if time allows. No? I shall now just move on. For all of those points which you would like to raise and possibly won't get in the session, here are my contact details if you'd like to make further contact and to discuss them. Thank you.
Thank you very much, Elizabeth. So I don't know if you could feel this, but Elizabeth is doing really an amazing work mapping all the privacy problems of the planet in relation to gender. It's really very, very difficult, and she does this in this very precise way, so that's very valuable. In the context of her work, she also does consultations, and this is how I met Anja. Kovacs is the director of the Internet Democracy Project. She's based in India, and of course, when you hear these kind of assessments, you can very easily be depressed and worried and scared, but we can also sometimes be optimistic about with the fact that there are some people out there in this planet who really care about these issues, and they try to change the situation, and they also have very, very interesting arguments, and one of them is Anja, so please, you have the floor.
Thanks, Gloria, and thanks so much for having me here. I work with the Internet Democracy Project. We work towards realizing feminist visions of the digital in society through taking as our starting point research on norms, governance, and infrastructure. We're also part of the Data Governance Network, which is a network that specifically seeks to deepen knowledge about data governance issues in the context of India. My work is very much based on global South realities, but I think the impact of what we do or the relevance really extends well beyond that. And on this question of extra-sensitive data flows, so I want to talk both in terms of non-normative gender identities as well as non-normative sexualities. I think the starting point really is what is extra-sensitive data, right? A story I wanted to start with is when we were looking into the gendered implications of Aadhaar, the unique identity that India has and that you might have heard of, we met a transgender person in East India who explained that many of the people she works with in her work as a transgender activist, so other transgender people, engage in sex work, which is common in India. It's one of the few options of employment that's often open for transgender people. More and more, they had started to use a digital wallet called Paytm to receive payments from their clients. At some point, the Indian government actually ordered that Paytm, the digital wallet, had to be linked to Aadhaar, which has gender as one of the fields that's visible to any company. Now, simply the link between their regular income into that account and the fact that their transgender identity was visible made them worried that they would actually come under scrutiny of the tax authorities for engaging in sex work because it is such a common profession in India for that particular group. And so even though, strictly speaking, you would think gender identity in itself is not sensitive information, getting money into your digital wallet is not sensitive information. For them, the way these items were linked really became a challenge. And so to think about extra sensitive data in the way as if it would only be about, for example, your sexual orientation as such would really be far too limiting for many of these groups. Now, how do you solve that challenge? And what we are arguing at the Internet Democracy Project is that it's impossible to do that with the current framings. I think I've been in sessions across this event where people have been saying human rights seem to be disappearing into the background. We have a real concern about how our institutions are supposed to regulate this. Is data protection enough? Do we actually have a language? At the moment, many of us don't have a language. And the reason is because we still talk about data as a resource. This continues to be the starting point. And I think that's true even of the GDPR, actually, even though GDPR maybe makes the link with people slightly stronger than in many other legislations. Why is this data as a resource a problem? We look at data as something that is completely disembodied. That's kind of a layer that's there in everything, but that you can take out of that thing and it won't change the thing that it was in, right? This is the big reason why we give so much power to data as truth-telling. And the most extraordinary examples, I think, of this are when scientists talk about the day that we can download a human brain into a computer, and that would supposedly be still a human brain. That is acting as if the body in which that brain sits doesn't matter. But if you talk to people of minority sexualities, transgender people, religious minorities in most countries, Dalits in India, you will know that the body that you are in actually has an effect on the experience of the world. And so that brain is not going to be the same. In a conference like this, I'm sure many people are aware of the ways that technology and data extraction are really imbricated in all kinds of power relationships, and that the fact that we don't have control either over the data that's taken from us in many cases or where it goes, or over the way categories are constructed and where we are slotted into them in the first place is a really big issue that makes some people much more vulnerable than others. And again, a straightforward example, which is much more tangible, is when you stand in the airport in that machine where they scan you in security, that officer has to choose whether you're male or female. Now, if you're a butch lesbian, if you're a transgender person, those become moments of great discomfort because there is no box for you, right? This is a visible example, but actually in a data-fed society, things like this happen to us all the time. And so there's much more to say about the erasures that data as a resource performs, about the normalization of extraction that it's actually allowing to such an extent that some people have started to talk about this as having structural parallels with the historical exploitation that came through colonialism. But I want to move to the alternative. And so what we are arguing is that we really need to start from people's experiences again and put bodies back into this debate as the container, the marker for difference, the originator of much of this data, and also the carrier of the harms that actually occur as a consequence. And we built on the work of a Dutch scholar, Irma van der Ploeg, who has been arguing that the line between our physical and our virtual bodies in practice is actually becoming irrelevant. Another example, in Florida, there was a transgender person who had transitioned from male to female and so had breasts, but their driving license still said they were male. They decided to do an experiment together with an academic friend because the law in Florida at that moment said, if you're a man, you can drive around topless, but if you're a woman, you can't. So the question was, would they be stopped by the police and what would happen? Now I'm telling this story, obviously, because the institutional data won. They were stopped, but because the driving license said the person was male, the physical body did not matter. This might sound like a freak story to you, but I have lists of these by now. This is the way our bodies are fundamentally changing. It's not just that data is embodied, and we are not talking about data as body as a metaphor. This is a paradigm shift in how we conceptualize our bodies, which is actually quite similar to the paradigm shifts that happened when scientists in Europe started to cut open people. The way we looked at the world changed, not just the way we thought about our bodies. And most of us now don't think of the limits of, or the border of our body where your skin touches the air. Our sense is that there is a bigger cloud somehow hovering around us. If we put bodies back, the question becomes, what do they need? And we've actually been really heavily influenced by Julie Cohen's work on privacy as boundary management, which I think is a really good starting point, because this is something that we all do every day. We're constantly negotiating. How much do I share with this person? In which context do I share it, etc. And the breakdown of our ability to do that boundary management is really what that transgender person who's doing sex work, for example, is facing, right? By putting bodies back, we can take these moments of discomfort and those actual experience as the starting point to read the networks of power that datafication has created and ask what should be changed from that perspective. And I think 2 points there are particularly useful as you read these networks of power. One is clashes in normativities, and this is anybody in this room who has ever typed something into a search engine and felt a moment of discomfort. That moment of discomfort comes because you really think things should be one way, but they are another way. The ideology of the system you might be using, what they are doing with your data, is not aligned with how you think it should be used, because you're worried about what is going to happen in that moment. In the morning, actually, I was in a really interesting session where one of the speakers spoke about, for a house to become a home, it seems we need to have a feeling of control over that space. And so when in experiments people were made to listen to the recordings of Alexa, it really undermined that sense of control. Those are the clashes in normativity. And the other issue is the actual harms. I find it really interesting. We have a data protection bill under discussion in India, and like in many countries, it has a long list of harms in the beginning. It includes bodily, mentally injury, discrimination, blackmail or extortion, etc. But none of the offenses in the bill actually address these harms, right? Because data protection regulation doesn't. While if you ask victims of the non-consensual sharing of sexual image how they experience the harm, most of them are not going to say, oh, that was a data protection violation. Most women who have faced that talk about it in terms of sexual assault. We are not able to address that because we think about data as being at a remove somehow. So What we believe is that by putting bodies back into this debate, by making that link again between data and bodies, by recognizing that data is embodied and that our bodies are becoming different, we can start to ask completely different questions of the ecosystems we are in, and ask completely different questions both in terms of the protections we meet, what that means substantively, but also at the structural level. So for us, this is not just a question about individual rights. When you ask what does it mean to provide that protection, you do also come to the political economy of how some of this is organized. And are able, I think, to much more fundamentally start to say that some things that are happening today should just never be allowed anywhere. So I'll stop here. Thank you.
Thank you very much. Now, this is the moment where there might be some little disappointment for you if you're coming here because of the written program of the conference. We had invited originally the data protection officer of the dating app Grindr, and because we really think in a CPDP spirit that it's very important that we have all sorts of stakeholders, and she was very happy to come here. She was really looking forward to coming here, but a few days ago, 10 days ago, some consumer organizations in Europe published some reports with some allegations saying that some data that is given to Grindr flows in strange ways, and as a consequence, the DPO of Grindr had to apologize, and she preferred to stay and focus on the follow-up of these allegations and complaints. You might be disappointed. I was very annoyed because these consumer organizations killed my panel, and I thought, well, if they can kill my panel, maybe they can save my panel. So I called them, and they were very happy to actually help us and be here. And we have, therefore, Marian Fernandez. She's from BEUC, from the umbrella organization of European Umbrella Organization of Consumer Associations. She has a lot of experience also with the digital rights activists, and she will explain why they do this to me.
First, thank you to both Grindr, Gloria, and CPDP for having me here. So, as Gloria said, today I'm going to talk about the work that has been led by one of our members, the Norwegian Consumer Council. And I'm going to talk about the report called Out of Control. Because basically we have found, and we think, that the current ad tech ecosystem is really out of control. And so, our colleagues have analyzed 10 popular apps. So those apps included 4 dating apps, including Grindr, OkCupid, Happen, and Tinder, a makeup app called Perfect 365. Apparently the Kardashians use it. The period tracker apps, My Days and Clue. Mighty Talking Tom too, so it's a children's app, and Wave Keyboard app. And so all of these apps were found to be sharing data with multiple third parties, and all except of one were sharing data beyond the ID advertising. And actually, in cooperation with other organizations like NOIB and also the cybersecurity firm Mnemonic, our member actually conducted an analysis on both the legal terms and technical terms about these apps, and they decided to take action at least against 6 companies to give an example about how this ecosystem is just, absurd. It's just massively breaking current rules of data protection in the European Union. So they decided to bring 3 complaints against Grindr and against 5 ad tech companies. So those are Twitter's Mopup, AppNexus, which is owned by AT&T, OpenX, AdColony, and Smato. I guess you knew perhaps some of these 10 apps that I mentioned in the beginning, but probably not any of the 5 ad tech companies I mentioned. And that's why we think it's very important. So then the research actually was done in Norway, but some of these companies act, or all of these companies act at the European and global scale, and that's why NCC, so the Norwegian Consumer Council, was joined by 10 members of BEUC from the Netherlands, Greece, Austria, Sweden, France, Slovenia, the UK, Denmark, and Switzerland to bring these findings to the attention of the data protection authorities. And even though the action was only done against 6 companies, it's important to say that it's just to set an example, and then more complaints can be issued against hundreds of thousands of companies, actually. So I'm just going to take a few of these companies to give an example about this tremendous shadowy ecosystem. So let's talk about Grindr, right? Since they cannot come, I can talk about them. So Grindr, for those of you that don't know Grindr, it's one of, it's the biggest dating app for gay, bi, trans, and queer people. And it transmits data according to this analysis to 19 companies. And you may think, well, 19, seems manageable. But it happened that many of these companies actually at the same time share data with other companies. And then those companies at the same time can share data with other companies. So one of these 19 companies is MOPAP. MOPAP says that it reserves the right to share the data with 170 partners. And one of those 170 partners is AppNexus, which at the same time also reserves the right to share the data with 4,259 partners. And, we stop there, because we cannot just go and finding what these 4,259 partners are going to keep doing. So basically, we demonstrate that massive collection and exploitation of data happens. And shortly after the publication of this report and the actions, MOPAP, which belongs to Twitter, said, okay, sorry, we just suspended, a Grindr from our ad network. And you may think, oh, great, this action is great, unless you remind yourself that MOPAP actually says that it's linked to 49,000 applications. They say that they track 1.5 billion devices, and they serve 450 billion ad requests in apps per month. So it's like, well, thank you, MOPAP, for just making it instead of 49,000 apps to 48,999 apps. Thank you very much, right? I also want to talk about another app that were not subject to the complaints to show that it's not that these apps and these ad tech companies linked to them are just, great. In fact, OkCupid, another dating app, beyond sharing advertising IDs or geolocation or other types of data like that, they share really intimate information. How many of you have used OkCupid in this room? Right. So at least these people that have used it, and for those of you that don't use it, I can tell you that when you open an account in OkCupid, you need to respond to a few questions because, you want to find the love of your life or just a hookup or whatever you want to do with it. And some of these questions may seem a bit banal, like what kind of movie you like, but some of the questions that you need to answer is like, do you do hard drugs? Do you think abortion should be legal? Do you think transgender people should be part of the military service? Would you be up for having sex in your first dates? How do you like cuddling? And those kind of questions are very intimate. And so OkCupid is sharing these data with, again, many other ad tech companies. And one of them that our technical analysis showed is shared with an ad tech company called Brace, which is based in New York, and they take pride of saying that they actually process data of 1 billion monthly active users. And so as you can see, the scale in which this online tracking and data exploitation that happens on a daily basis is just huge. And the lessons that we've learned is that we're facing a massive industry, that these companies are not obtaining valid consent according to the rules that we have in Europe with the GDPR. I'm sure you have heard this acronym before. And so even though some companies actually claim that they can be based on legitimate interest, in fact, the freedoms and rights of people would outweigh anyway whatever legitimate interest these companies may claim. So they are doing it, in our opinion, in a way that is not compliant with the GDPR. But on top of that, actually we have noticed that it's not just about, a data protection violation, and I'm happy that the previous panelists touched upon that, because it's actually about consumer harms as well. With all this massive data sharing, consumers are experiencing a lot of harms like discrimination, exclusion, manipulation. and all the chilling effects that massive commercial surveillance systems have on our society and democracy. And so consumers really cannot avoid being tracked in this ecosystem. First of all, people are not really provided with appropriate information. And the second thing, even if they were, the state of tracking and the standard of data sharing and general complexity of this ecosystem would make it almost impossible, not to say impossible, for anyone to meaningfully control the system. So we think that it's about time for these type of companies and their partners to actually stop, right? Because what we need is efficient and quick enforcement of current rules. We need changes in the digital marketing and ad tech industry. We have noticed that there are other companies that are trying to provide alternative business models. So an alternative is possible because, you know, some of them may say, well, everybody's doing the same, you know, so why me? And it's like, well, but there's proof that you can do it in a privacy-friendly way, and you don't actually need to share whether I like having sex in my first date with millions of people, companies, and make money out of it, right? And so this is the point. We need to change the mindset, and beyond data protection, there are many other human rights that are being infringed. And also there's a competition implication, because these companies are actually reinforcing the market power of certain companies that already have massive amounts of data. And actually, they're discouraging other companies that are trying to provide privacy-friendly alternatives. And so we just want, you know, the compliance and the embedment of privacy to pay off, right? We have the rules, these need to be enforced, and we expect data protection authorities, not only in Norway, but in Europe and also in the US and other countries where the action took place, to actually act. So, you know, I hope that the next report will be in control instead of out of control. Thank you.
Thank you very much. You said we have the rules. So that's already an interesting idea. Do we have all the rules, or I don't know. I've been organizing panels around gender and digital rights for a little while, and I know it's always very difficult for us to actually get somebody from the policymakers, institutions, especially European institutions, because we know they care, they are involved, they have policies around digital rights, they also have policies around gender, but there are not so many experts that really do this link between digital policies and gender. And last year, I was on Twitter, just giving my data away, and I saw a new profile that I've never seen of a member of the European Parliament, and the little description is digital rights and feminism. And I said, ooh, we really need to invite this person to the next panel. So I'm very, very pleased to have here with us today Alexandra Geese, I don't know. Yes, so I'm just only reading Twitter all the time. I don't talk with human beings. And so please have the floor.
Yes, thank you. Thank you very much for those kind words, and thank you very much for having me. This is perfectly true. I don't have a long digital rights background. I have a more feminist of background, and then at a certain point I realized that digital technologies are not only changing the world and society in general, but that they can have a potentially detrimental impact on women's rights, on the rights of people with a different ethnic background than the majority of the population, people with a different sexual orientation, and so on. And so I looked around in my party to see who's dealing with it, and actually nobody did. There were the feminists, and then there were the digital rights people, and they did not talk to each other at all. So that was my first challenge, and I'm very happy to be here now in the European Parliament and to put forward these kind of policies. Obviously, we are very happy to receive input because it's not easy, but I think we're very grateful for CPDP organizing these kinds of panels on gender and privacy and so on. So the privilege to be the last to speak is that I can pick up aspects you all mentioned. The disadvantage is that I can't use my notes because you already said everything. So I will try to touch upon a few aspects and to figure out what legal instruments are relevant for our discussion, because in the end we need a change of mindset. But if you think of the millions and billions being made with ad tech, I don't think we need a change of mindset. We need a change of legislation and of law enforcement especially. Then we have this strong contradiction in Europe that we probably have the strongest legal instrument to enforce privacy anywhere in the world. GDPR has become a global standard. We're all very proud of it. It should be enforced, but still we are seeing really serious data breaches or gray zones with the situation Marion described. I think the results from Privacy International and the research from the Norwegian Consumer Protection Organization from January this year are absolutely shocking, because they show that apps that collect very, very sensitive data share them with the whole ad tech industry. You know, in the beginning we said we might be talking about ad tech as well, and this is what we are doing. Real-time bidding in today's digital advertising, it just breaches our fundamental rights. It's a systemic, massive, and ongoing data breach. And when companies engage in comprehensive tracking, categorization, and profiling based on vast amounts of data, this places the consumer at a significant disadvantage. Think about emotional targeting. And then think about the gender aspects of emotional targeting. So what do menstruation apps basically want to find out? They want to find out when you get pregnant. Because when you get pregnant, you're particularly vulnerable. You're in a different hormonal state. And I really liked what you said on the body being part of it. Because when you speak about gender, you have to speak about the body. Women have different hormones. This is very interesting when you look into research for medical purposes. Most research for medical purposes is done on men, because women have all these pesky hormones, which is one of the reasons that certain drugs don't work for women, just, you know, as a sideline here. So I think this is very important to consider. So once you get pregnant, you start being bombarded with ads for equipment, for babies. And I mean, that might even be okay, but think about postpartum depression. And ad tech companies finding out about that. So you're in a particularly vulnerable emotional state, and everybody knows about it. And that's dangerous. We talk about Cambridge Analytica and political micro-targeting, which is obviously something politicians worry quite a lot about. But exploiting particular hormonal states, which women particularly have, and particularly women going through a pregnancy or giving birth, might be even worse. So I think that's a danger to democracy, and that happens although we have GDPR. So does that mean that GDPR doesn't work? No. We should be proud of GDPR, we should support it. But I think we should highlight these cases in order to make clear that enforcement of GDPR is absolutely essential, that the DPAs in the member states need appropriate resources, that we have to whip up the political will to staff them and equip them adequately. And I think we need more NGOs and consumer protections organizations to do the kind of work, and we need you to have better funding to be able to do that. To have more time, more staff, that's such an important role. So I think this is something we can do in politics, try to support you as well as we can. And there's something else I want to mention in terms of legal instruments. So what is this data used for? Obviously for targeting people with ads. But you know, there's a huge debate now on the framework for artificial intelligence that the Commission is going to put forward in February. It's going to be a white book, not a legislative instrument. And the data strategy which will come, which Commissioner Breton promised. And one thing we know is that a huge amount of the data that is used to train algorithms, automatic decision-making systems, is not obtained in a perfectly legal way, according to GDPR at least, if measured by GDPR standards. Think Clearview, for example. I think that was just such a huge contradiction. Clearview scraping Facebook and social networks for pictures in a clearly illegal way, and then it's used by the police. So I think there's something that doesn't work. So something we should look at in the artificial intelligence debate is definitely, where does the data come from? Can we put legislation into there to make sure that only data that is legally obtained can be used? Because otherwise this is going to be the new huge business opportunity for ad tech, not only using it for placing ads, but also for selling these data to people who need to train their algorithms. And this is going to be even worse, so I think we have to think about some kind of wording to get into future legislation on artificial intelligence in order to make sure that all this data is legally obtained. And this has a huge gender dimension, because we know that automatic decision-making systems are highly biased usually. The data sets are biased. The teams working on algorithms, on the modeling, are usually 90% male, 90% white. And this is something the Commission knows about and is sort of addressing, but I think the criteria they're talking about, from what we know, are still too selective and will not be enough to avoid this. So we will have a double problem of data being illegally or in a gray zone obtained in some way that feeds into algorithms made by white, rich males with no kind of gender dimension or diversity dimension, to be more inclusive, obviously. And this is not only a danger for individuals concerned, for individuals excluded from recruitment processing, from access for housing, for example, but it's really a huge danger for society. I think if we don't get this thing right, we will have a rollback to, I don't know, the 50s of the previous century or even worse. I mean, let's not forget that women's rights, minorities' rights, rights of people with a different sexual orientation, even in Europe, have been obtained very lately. You know, when I was young, I mean, you didn't talk about people who were not heterosexual. It was something, oh, you don't talk about that, you don't touch it. It's just that this is something I experienced in my lifetime. Or when I was a child, my mother wasn't allowed to work without my father's permission. So it's just on the surface, and I think you all pointed out the problems. So with the digital legislation that come up, we really have to make sure that the gender dimension is adequately considered. So this is the AI legislation framework for the, technically speaking, at the moment, it's going to be a white book. But you're all welcome to submit good ideas we could feed in, because I think there will be legislation. I think Europe will be really a global leader on legislation on AI, and this is why it's so important that we get it right and that we learn from the good sides, but also from the bad sides of GDPR. And then there's obviously the Digital Services Act, which is not that close to privacy, so sorry for that. But since Elizabeth mentioned hate speech and young women being disencouraged from engaging publicly, I think this is very important, and it's very important that we find solutions and strike the right balance for freedom of speech for everybody within the Digital Services Act, and I think that's closely related. And so I'll leave some time for the question. Thank you very much.
So, thank you to all speakers. I would already like to open the floor for questions. We have touched many different subjects, so I do hope there will be questions. There are 2 microphones there. I've been told if you are lazy, tired because of the party yesterday, you don't want to get up, they can bring the microphone to you. So there's no excuse, really. Please do think about questions that you would like to ask. I have many questions. I have kind of a technical one for Marian, because you did this assessment of the legality of compliance, lack of compliance with GDPR. Did you assess specifically the transfer? So was this presented as an international data transfer to another country potentially not adequate, or was it just illegally processed as such? Or you...
So the first thing to clarify is that this was a global action. So as I said, the research was done in Norway. but more than 20 organizations have been part of this action. And actually, as was mentioned also by Mrs. Geese, they have built on the work of other people, some of which are here, like Johnny Ryan from Brave, Open Rights Group, Privacy International, Michael Veal. They also have helped from other researchers. And I mean, some of these companies actually are not European, but they have, 2 of them have the European headquarters in Germany, 2 of them in Ireland, and 2 of them do not seem to have a European headquarters. They are actually based, one in New York, if I remember correctly, and the other one in California. And so at the same time that the Norwegian Consumer Council issued a complaint, and our members also other members notified their authorities. US groups and other groups have also notified their respective authorities. So also in California, because of the CCPA, there's an opportunity to actually even the level playing field. And because of course, some European companies that actually comply may be like, well, I'm just complying, and these hundreds of thousands of companies are not. And so we presented not just as a European issue, but a global issue. And precisely in the complaints that we presented in Europe, in Norway, and that NOIF will actually present similar complaints in Austria, we focus, of course, on the GDPR, because that's the grounds for complaining before data protection authorities. But we make clear that it's a global issue, and it would not be enough if, for example, these companies just make changes in Europe because of the GDPR.
Thank you. Yes, if you can identify yourself. And we can see. Yes.
My name is Johnny Ryan. I work for Brave. Anja, your intervention was profound, and it raises a big problem. How have you found ways in conversations with lawmakers in any jurisdiction, but especially, I know you're focused in India, but especially in more capitalist jurisdictions, to reintroduce the body? Because already there's this disconnect, even in Europe, in separating out data protection from property. That's the starting point for many people. And in the States, it's the end point as well. So if you were in my shoes and you're lobbying in the EU and in the US for that kind of protection, what language are you using? Is there a way to do it? Because it sounds necessary and impossible, and I'd like to know how to do it.
So I have a 50-year plan. And I think that's really important. I find, for me, this conference was really interesting because it's the first time that I've actually been in an event with so many people who are experts on privacy together. And there are so many panels that I listen to and that I think are fantastic. And that are raising issues that I think, but why don't you make that connect? Because it makes pushing your issue so much easier, putting your questions on the table so much easier. Like this is for me, it's really a uniting frame. Like I said earlier, I think we're in a paradigm shift, and that's why I said it's a 50-year plan. In 50 years' time, I genuinely believe we are going to look back at this moment and say, why didn't they see that? What were they thinking that what she was talking about is okay? How was this allowed? How could we not see how fundamentally this is undermining human dignity? Part of the reason that we're doing this kind of huffing and humming, trying to find red lines, is because we're kind of accepting the status quo as it is. Third-party selling happens. Business models are based on it. A lot of the ecosystem is based on it. And so that's what we're dealing with, right? And I think for me, this narrative around the body is a way to start asking fundamental questions. Now, it is hard with policymakers, and what we are doing in our work actually right now is, apart from developing the theoretical framework further, is also kind of trying to see, so what does it mean specifically if you talk, for example, about consent? Now, if you put bodies back into the conversation about consent, already your focus shifts. We talk about consent in data as if it's the same as in consent in sexual relationships, but the way it's operationalized in data is contract law. And I find it striking, how is it possible that supposedly privacy is the one fundamental human right that we can actually tick a box to sign away? Every other fundamental human right, we have agreed that there is an essence to this right which you can never sign away. So the right to life, you cannot agree or consent to sign yourself into slavery or bonded labor. No democracy allows that, right? You can't agree to sign away your right to freedom of expression. Why can't we do this? Can't we see the same with privacy? And so I think reports like this panel I mentioned in the morning about like the home as this private space, the way datafication happens is so intimate now. Questions about how that undermines human dignity come up here all the time. And I think for me what's really striking is even policy, also techies that we speak with, the point is to find the right example because every person has experienced this. And at some point they will say, yes, I get this. And then the thing is to collectively, because obviously we're not going to do this alone at the Internet Democracy Project, but to start thinking, so then what are the fundamental ways of reframing things? And so consent is one area we're looking at. Another one is on biometrics. We're trying to trace parallels in historical debates around surrogacy, organ transplantation, bioethics, and slavery to see where does commodification cross an ethical line where we say this is undermining human dignity. Because there will be lessons to learn from these things. And by making that connect with the body again. And so I think much more work just has to be done like that so that we can fill the frame. But the starting point with anybody, policymaker, anybody else, is did the example touch you?
Yes, and if I can follow up on that, I think that genetic data has a lot of background on that. Genetic data is the classical example where actually there was a disembodiment, and especially there is a push towards open data where genetic data is presented as any type of data that can be anonymized while it's telling us so much about sexuality, about how we are. It can be used to target people, to identify people, to describe their sexual identity, even though it cannot describe their sexual orientation yet. So I think this is something where it's useful to look at, and also the push on the policy side that there is to really recognize data as something ephemeral, not dangerous, that can be used lightly. So I'm super interested in the work you are doing because, I think it will have great implications also on that. Thank you to the whole panel. This was super interesting.
I think there was no real question, but if you want to say something about genetic data, you can.
Maybe just, I think we started from things like biometrics because it's the most literal translation of the body into data, right? Like we're now to prove that you are who you say that you are, supposedly we need to have all these kind of much more intimate data sets out there. And then if the system says you are not who you say you are, then you are not, right? And it's again, I mean, earlier people were laughing with the transgender example in Florida, but in India, we have had fingerprint identification failures leading to people not getting rations, which they have a right to under Indian law, and then leading to starvation deaths. You can't solve that through a data protection legislation, right? That is a right to life issue. It's an issue of bodily integrity, etc. But the shopkeeper, the ration shop owner might know that you are who you say you are. They might have known your family for 30 years. It doesn't matter if the system doesn't register. The thing is, I think this is true even for much more like innocent data in a way. And if you look at location data, I still think it's interesting. If somebody would follow you and trace your footsteps everywhere, you would think they're crazy, right? It's just because it's become this intangible thing, somehow we were okay with it.
Thank you. If there are no other specific questions, I would like to come back to you, Elizabeth, because there was a mention of the leadership of Europe in artificial intelligence and how this can be connected, or should be connected to gender. You have been also mapping initiatives about artificial intelligence and gender. Can you tell us more? Do you see, I think there's a general agreement that there is something about gender that we should remember when we talk about artificial intelligence, but are there good initiatives?
I think it's, the relationship between gender, in that very broadest, inclusive sense, the way that I described it, and artificial intelligence is incredibly important because it is so very, very difficult to actually understand what is the algorithm that determines artificial intelligence based upon. Is it using historical data, which is always now based upon cultural norms and our attitudes towards what is appropriate gender behavior? And how too do we actually use that in the future going forward? You know, how do we see artificial intelligence related to gender issues? And in turn, how is gender going to affect the way that artificial intelligence is developed? And as I see it at the moment, I'm not seeing those sorts of avenues for influencing, for understanding, for determining and influencing. Virtually every session I've been to, in unfortunately only the 2 days that I have been here, has raised the issue of the bias in AI. But I'm still to actually hear a process whereby we can understand and unpick how AI is actually working and the means that we have to see transparency in that process. And I think if I could just make a reference to another issue which is related to this issue of transparency. As I said, our work has very clearly demonstrated that we have this differential experience of privacy, one of which determinants is gender, influenced by other intersectional factors. But when you take that issue forward and look at data protection reporting which is done publicly, for example, through annual reports, I wanted to see if, okay, women experience privacy differently, or transgender have particular problems. How is that reflected in public reporting by DPAs? So we did an analysis of all of the annual reports that we could get for a particular period, which are on the International Conference for Data Protection and Privacy Commissioners. So we ended up actually analysing 122. And I'd like to acknowledge my co-author there, Cara McKee. We did not find, with the exception of one, that actually totals were disaggregated by just binary gender, male and females. Because a very fundamental question is, do men or do women use DPAs more than other genders? It's incredibly useful for policymakers. You need to understand why people go to DPAs. And look, I will also acknowledge that as a former DPA, of which I spent 6 years in that role, I did not pick up this issue adequately as well. So, I'm pointing the finger back at myself. But you'd need to actually unpick some very, very basic service sort of orientation issues if we are going to address this at the level where it really helps people. And if we don't know who's using DPA's services and for what, how can we actually work out such matters as, are they adequately resourced? Does the legislation, does the policy really meet their needs? And that's one of the issues which I think is really very incredibly important and relevant, is how does our legislative regime at the moment, our policy regime, our programs regime, fit with this gender perspective of privacy?
Thank you. I think it's we could discuss for many hours the relation between artificial intelligence and gender, but because we have 5 minutes, I would like just to come back to the question of sexual orientation. And because we are building on 3 days of conference, at some point during the conference, Anja tweeted something about these many programs that try to just identify the recognize the sexual orientation of people based on facial recognition or whatever. And Anja, you had some critical comments about this technology. And because, Alexandra, you were mentioning that perhaps there are some things that should be declared illegal. is this something that could be declared illegal? That we have this... Good. Yes. That artificial intelligence for the automated recognition of sexual orientation, is this an example of something that could be illegal or is already illegal but it's not really remanded to people, or should this be perfectly fine?
In my opinion, it should be illegal, definitely. Well, we've been discussing in the past weeks a little bit the total ban on facial recognition in public spaces. I think that would be a very good beginning. I think that would be very good to have a campaign on this now that the Commission has looked into this option, and we see whether in the white paper in February it's going to be in there or not. I think that would be a first start, which is very important in itself, and it would raise awareness for the dangers of facial recognition combined with artificial intelligence, ADMs, and so on. And it obviously, in that case, there's a fundamental right of privacy and on sexual orientation concerned. So I'm not a lawyer, but in my view, that should definitely be illegal, yes. I'm not sure whether it is under current legislation. It's probably not, because people keep talking about being able to do it. But I think it definitely should be, yes.
Yes.
So actually the thing I tweeted was about this study done by a Stanford associate professor and I think a PhD student in computer science at a university in Europe a few years ago, which basically found that deep neural networks can predict somebody's sexual orientation based on facial recognition more effectively than humans can. And I think the effectiveness was 80%, and for humans it was 17%, and this was for men, because for women it was lower. And it seems computer scientists are still discussing whether or not deep neural networks can actually do that. And I think that research is trash simply because of the question it asks. And this is, for me, one of the things, again, if you put bodies back into debate, you can see that this is not actually an ethical question to ask, and how that was passed by the ethics research board of one of the most famous universities in the entire world is really beyond me. And I think really shows, again, this cognitive gap. If we would actually have seen the human beings, the fact that actually not being heterosexual is still illegal in so many countries in the world, the fact that people are killed because of that, then you're not going to ask that question even. Why? Because you can. There's also people who have pointed out that actually that kind of work is very similar to phrenology in the 19th century. If you look at the Rwanda conflict, a really important factor in that conflict, if you go back to the origin, is actually the Belgian colonizer measuring people's heads and noses, facial features, and dividing them into Hutus and Tutsis. Now, how is looking at facial recognition and coming up with something like this really radically different? And so I think these are questions about human rights, civil liberty struggles, which we've fought the entire 20th century, and now just because data presents like it's there, we're throwing out of that all of the window again. So yeah, I really think that study is trash. It should never have been done in the first place.
So, thank you very much. I don't know if you want to have any final thoughts, final questions. Otherwise, I think because we are really just on time, I would like to thank very much all speakers, and I really hope to see you on the main stage at this good timing next year at the next gender feminist panel of CPDP. Thank you.